Today, I'm going to talk about discrimination based on race, skin color, and national origin, which were outlawed by Title VII of the Civil Rights Act. When I worked as a federal investigator at the EEOC, I helped many people use this law to successfully rebuff racial discrimination. I'll talk about some of the unique characteristics of discrimination based on race, color, and national origin, such as harassment, English-only rules, and discrimination based on appearance. This is not legal advice. I'll also highlight some of the less common forms of discrimination on these bases. For example, sometimes people experience discrimination not because of their own race, but because of the race of their friends and associates. I'll also highlight some of the policies that can create a disparate impact on African Americans, non-citizens, and other protected classes. Use the chapter links to skip to the topics that relate to your situation. First off, it's important to understand the definitions of race, color, and national origin as they relate to discrimination. Each has distinct characteristics. You could experience one, two, or all three as bases for employment discrimination. Race discrimination is discrimination based on ancestry or physical or cultural characteristics typically associated with groups with shared origins from broad geographic locations. Examples of races include white, African American, and Native American. Color discrimination is discrimination based on the relative lightness or darkness of skin complexion. Latinx and African Americans are the most likely to experience discrimination based on color. Usually, light-skinned people experience less discrimination than those with darker skin. National origin discrimination is discrimination based on an individual's or ancestors' place of origin. Examples of national origins include Latinx, Mexican, Iraqi, and Japanese. Because of these protected characteristics, employers cannot discriminate based on birthplace, ancestry, culture, or linguistic characteristics closely associated with an ethnic group. Harassment that creates a hostile work environment because of race, color, or national origin is illegal. The creation of a hostile work environment depends on the frequency and severity of the conduct and perceptions of the victim. Employer liability hinges on the employer's knowledge of the harassment. My video on sex discrimination and harassment provides a detailed explanation of what you need to prove for hostile work environment. Proving racial harassment differs from proving sexual harassment. Demonstrating the unwelcomeness of a racially harassing environment is easier. Employees occasionally mutually agree to engage in sexual relationships, but rarely encourage coworkers to utter racial slurs. Harassment can directly reference race, color, or national origin, and can include smears of cultural characteristics, like dress, language, or accent. Since racial harassment is often limited to verbal comments, proving that the severity of harassment rises to the legal threshold of a hostile work environment can be more difficult. Just like with sexual harassment, management must know of the racial harassment to be held responsible. A company can be held responsible if management would have known about the harassment, but did not because its racial harassment policy was non-existent, confusing, or rarely enforced. When an employer knows of harassment or should have known of the harassment, it has a responsibility to take action. Employees expressing ideas in their native tongue irritate some employers. Some respond by creating English-only rules in the workplace. These declarations can have the effect of fueling a hostile work environment for bilingual employees or creating a disparate impact by subjecting them to more constrained conditions of employment. Employers can require employees to speak English at certain times when required by business necessity. Business necessity in this instance means necessary for the safe and efficient performance of an employee's job requirements. For example, Business necessity could justify requiring employees to speak exclusively in English when safety is at risk or when communicating with customers or coworkers who do not speak the non-English language. An employer must provide adequate notice before imposing this rule on employees. Under normal circumstances, business necessity does not encompass reasons such as the inability of supervisors to understand private conversations, customers' preferences that employees always speak English, and the desire to improve employees' language skills by speaking solely English. Requirements that employees speak English fluently or without an accent must be justified by business necessity. Often, the ability to communicate in English is necessary for an employee to effectively perform their job, but speaking English fluently is not. Accent discrimination is allowed only if speaking English is necessary for the job and the employee's accent materially interferes with their ability to communicate in English. For an accent to cause unsatisfactory performance, all accents must be unacceptable, such as a New York accent or a British accent. Very few positions can justify a requirement of accent-free English. As you may recall from the first video in this series, policies that have a greater negative effect on a protected class can create a disparate impact. Language policies aren't the only policies that are likely to create a disparate impact based on race and national origin. Employers' grooming and appearance policies can have a disparate impact on certain races and national origins. Dress codes affecting certain hairstyles traditionally associated with a particular culture, such as cornrows or afros, are discriminatory under federal law only if they have a disparate impact on a particular race or national origin, although a number of states have crown laws which prohibit discrimination on these bases. Policies having a disparate impact must be consistent with business necessity to be legal. For example, Domino's Pizza once instituted a no-beard policy. Nearly half of black males suffer from a genetic skin disorder, which in severe cases can force them to abstain from shaving. The court decided beardlessness is not necessary for the job of making or serving pizza, so Domino's policy was not justified by business necessity. Policies to only hire citizens or only residents of particular areas are prohibited when they create a disparate impact because of an individual's national origin or race. Under some circumstances, an employer can legally prefer applicants because of their citizenship status. An employer deciding between two equally qualified applicants, only one of whom is a citizen, can prefer the citizen. An employer can refuse to hire undocumented individuals working in the United States without legal authorization to work because of their immigration status. Yet, once undocumented individuals are hired, an employer cannot discriminate against them because of their race, color, or national origin. Other examples of policies that can have a disparate impact on protected classes based on race, color, or national origin include requiring good credit for applicants. This impacts non-whites because non-whites are often poorer than whites. Hiring primarily friends and family. If friends and family are from one race or national origin, opportunities are limited for others. Requiring applicants to have no arrest or conviction record. This impacts African Americans and Latinx because these groups have higher arrest and conviction rates. Even having questions on an application about prior arrests or convictions can discourage African American and Latinx applicants. An employer will have a much tougher time defending a blanket policy denying positions to all applicants who have been arrested than defending a no conviction policy. Even a no conviction policy could be difficult to defend if other factors are ignored, like an employee's good work record, the amount of time that has passed since the conviction, an applicant's efforts at rehabilitation, the type of conviction, and the type of position. If an employer hires people with some types of criminal records but not other types, the employer must conduct an individualized assessment of whether the specific crimes are job-related and consistent with business necessity. A number of states ban employers from asking applicants about arrest and conviction records. Some individuals extend their racial prejudice to include individuals who associate with people of various races, colors, and national origins. An individual might be targeted because they are part of a biracial marriage, attend schools, or participate in religious organizations predominantly composed of one national origin, or even because they have a foreign-sounding last name. Discrimination based on this type of association is illegal. Lastly, an employer cannot separate, organize, or group employees differently because of race, color, or national origin. We touched on a lot about discrimination based on race, color, and national origin. If you would like information about another protected class, like disability, jump now to the appropriate video in this series. Otherwise, check out the video which discusses retaliation. You need to know how to be protected when complaining about discrimination. But before you go, if this information was useful to you, hit the subscribe button so you don't miss out on getting the information you need. If you've experienced discrimination based on race, color, or national origin and have tips that might be helpful to others, please leave them in the comments below. Thanks for tuning in.